I've had the opportunity, like I said, to meet with something in the ballpark of like 60-ish chief privacy officers or data protection officers over the last 6 to 7-ish months. Nearly 100% of them have cited CIPA as a major priority for their organization. And CIPA, for those that don't know, is the California Invasion of Privacy Act, which is a law that was enacted back in like the 1960s or something as an anti-wiretapping law. But right now, law firms are exploiting this law by saying, well, there are ways that we can basically go through and make a claim that because your website is making these sorts of tracking profiles on us, and or if there are screen recorders, then we can sue you. And a lot of people are settling. So we're seeing millions of dollars of lawsuits come to be because obviously they're going back to this 1960s law to say it still applies today. And so calling out the CIPA lawsuit in particular, there are a handful of pixels that they're looking at. Facebook is one of the most common ones. So if you on your website right now, you have Facebook and you're not following the opt-out profiles correctly, you will, if you haven't already, you will receive a lawsuit. I can almost guarantee it because now law firms have the ability to basically go to Claude and say, Claude, does this website contain any of these tracking pixels? If yes, send them this demand letter. And they're just shipping those things out like thousands at a time. Other tools like Full Story or whatever that Microsoft Clarity version is, where it records your screen and stuff. If you have any of those on your website, it's not a bad thing, but just you have to make sure you're cleaned up and very tidy on things, or you will receive one of those lawsuits.